Okay, good evening, everyone. It's Tuesday, August 13th at 6:04, and this is the August meeting of the Board of Zoning Appeals. Can we have the roll call, please, Craig?
Yes. Mrs. Janis?
Yes.
Mr. Klinder? Mr. Norvell?
Present.
And Mr. Zimmer?
Here.
And Attorney Hale is also present, so you have 4 members, which is sufficient for quorum to hold tonight's meeting.
Great, thank you. And do we have the approval? Now we have the approval of the minutes from last meeting in July. Are there any comments, changes, or do we just get a motion to approve them?
Move that the July meeting minutes be approved.
Okay.
So we have a motion.
You have a motion and a second?
Yep. If we can take the roll.
Yes. So this is on the passage of the minutes from July 9th of 2019.
Yes.
Karen, I'm sorry, I was going to say Karen Janis, but Mrs. Janis.
Yes.
I'm looking at the words. And Mr. Klinder.
Yes, here.
Yes. Mr. Norvell.
Yes.
And Mr. Zimmer.
Yes.
It's 4 ayes and 0 nays on the passage of the minutes.
We will waive the reading of the policy of conduct and procedures, but have them inserted into the minutes. Next item is our one and only petition this evening, and Mr. Hale would like to speak to that.
Our first petition is petition B-104-19, and I would like to read to the members of the board an email I received just a few minutes before 5 o'clock this evening. Steve, thank you for taking my call this afternoon. As I explained, I have a scheduling conflict between the Michigan City BZA and the LaPorte BZA this evening. Additionally, we have no new information to offer the board at this time in response to their request at the previous meeting in June. For those reasons, we are formally requesting a continuance of the pending petition until the September meeting. I understand that this request may be seen in bad faith, and given the ongoing issues, I also understand that the city will likely object. That being said, my client states that he has engaged Keller Engineering out of South Bend, who has visited the site, but that their report is not yet completed. We have already received one continuance in this matter. Code section 2807C states that any other additional continuances must be made before the BZA, and the request may be granted at the BZA's discretion upon the determination of good cause. We feel that the need to provide the board with a complete record upon which to make their determination is good cause. Should the board grant the continuance, we would be agreeable to reserving notice on all appropriate parties. I regret that I will not be able to attend the meeting to make this request in person, as I believe the board and all other involved parties are due that respect. However, it is my request that you make this motion in my absence this evening. Should the motion be denied, there will be no one present on the petitioner's behalf, and Code Section 28.07 subsection B addressed a petitioner's failure to appear and the board's discretion in dismissing the petition. Thank you, Brad Adamski. As a matter of clarification, I would like to remind the board that we had a hearing in June, and according to Mr. Adamski, he presented some information. He opened up his case. And there was a continuance granted by this board in June. The minutes that you just approved for our July meeting also contain a continuance requested by Mr. Adamski for this petition. That request referenced obtaining additional information. I'm not sure if it specifically addressed Keller Engineering, but I know my memory is that there was a request for getting an engineering study. It was something that the city had talked about. So there have been at least 2 continuances to date. Mr. Adamski is requesting via this email that you grant another continuance. I would just note, as stated in that, but even more so, that section 28.07 of our zoning code states that the applicant may be granted a continuance of a public hearing for which a petition is scheduled but not acted upon and which has had a notice issued and published. The chairperson or his or her designated representative may continue a hearing for the first time if the applicant requests a continuance at least 24 hours in advance of any scheduled public hearing. Any other additional continuances must be made before the BZA. These requests may be granted at the BZA's discretion upon the determination of good cause. The BZA may further waive notice requirements. If any additional notice for the continuance is necessary, the applicant shall bear responsibility for notice. We stop there. I believe that this body may grant the petition for the BZA. However, section 28.07 of our zoning ordinance, subsection B, states the applicant or his or her agent must appear before the BZA in order to present a petition. Failure to appear can cause the petition to be dismissed, subject to the BZA's discretion. A petition continued more than once can be dismissed by the BZA or upon request by a remonstrator. So, this is telling us that, first of all, I don't believe you have the option to hear this matter in the absence of the petitioner. And so you cannot, although you've received some information, you cannot make a decision. I believe that your only two choices in the matter are to grant the continuance. I'm going to say three choices. Table this to an unspecified future date when it's brought off the table and rescheduled. Or you may dismiss because you're not granting the request for a petition or for a continuance, or you may dismiss because the petitioner is not here to present his case. So let me repeat. I'm sorry, I see some wondering eyes. The petitioner has requested a continuance, so you should address that and either grant the continuance or not. If you do not grant the continuance, the petitioner isn't here, so you're going to have to, at that point, dismiss, either because you're denying the request for the petition or because he's not here to make his case, to present his case. So it would seem to me that the first order of business would be to handle the request of the petitioner, which is to grant him a continuance to the September meeting.
And if we dismiss it, then he has to refile. Is that correct?
If you dismiss it, and by denying his petition, you would then have a motion to dismiss, he has to refile. He's got to wait a year.
Oh, okay.
He can withdraw it, but he cannot withdraw it after he's started his case, his presentation, which he has done.
Okay.
So that option is not open to us.
But you also said we could table this if we wanted to.
Well, that would be granting his continuance. I would much prefer, or my suggestion would be that you be more straightforward and just grant the continuance based on the reasons supplied by the petitioner, or just dismiss it.
Okay.
Craig, have you had any conversation with them, Skylar? Any conversation with them since the last meeting?
Other than the correspondence we received about the work being done by Keller Engineering, no.
At my request, if I may intercede, at my request, Skylar contacted Attorney Adamski last week and asked him what the status was.
Mm-hmm.
And there was a response, I think, late in the day last week that is similar to a response that came earlier this week that just said that he had this problem, that they did not have the materials yet, and he had this double booking, and he didn't know what was going to happen.
Craig, do you have any thoughts or feelings about this that you care to share?
Well, the planning department has been dealing with requests associated with this property for months now. And frankly, I do not believe that the petitioner is acting in good faith in terms of trying to resolve the issues that exist. We're going on a year and a half since the original violation that started this whole process became an issue. And we have been, I think, more than accommodating in terms of offering opportunities for meetings and discussions to try to resolve the issues associated with this property. We've had a number of times where the petitioner rescheduled the meeting, didn't show up for the meeting, a number of things like that, and this is becoming a pattern, frankly. I think had we gotten some sort of indication that something was happening between the last meeting and now, without having to reach out to the petitioner, to get that information, perhaps I'd feel a little different about the idea of continuing this. But frankly, I feel like, for lack of a better term, I feel like we're being strung along. There is a pending, violation associated with this, and so, we would like to resolve this issue. But at the same time, if the petitioner is not acting in good faith, I don't know that we want to prolong this, and I think we need to, put an end to, frankly, wasting staff time, public's time, and others, time on the BZA, having this continually brought before you with no progress being made by the petitioner. So my recommendation would be for not granting the continuance and dismissing this case. And then if the petitioner feels that after a period of time the project has changed enough that they're interested in bringing forward a project that complies with city standards and requires perhaps some sort of special approval for that purpose, then that's fine. But we've seen no indication whatsoever of that. In fact, we've been given information that in various meetings that the petitioner is working on a solution that does comply with city standards, but we've had no evidence to that to that effect at this point. And I frankly don't feel like we should prolong this. That's my recommendation. My recommendation, and I believe Mr. Hale feels comfortable with the idea of not granting the continuance and dismissing this case. But we have grounds for that, I guess I should say.
Does that shut them down?
No, does not shut him down. What it does, though, is it reopens the issue of the violation, which needs to be addressed anyway.
So what does that mean?
It means we get back into conversations with the owner about resolving the violation that exists. And then if something comes forward that complies with city standards that's summarily different from this, I believe we could make an argument that there's a possibility of bringing us a different solution forward. If it's necessary if there aren't any approvals in the form of variances or anything like that necessary at that point. But right now I feel we have no indication whatsoever of what that solution looks like. And frankly, I don't think we should prolong the conversation. If he comes forward with something that helps resolve the issue, and perhaps it requires some sort of variances, at that point, I think it's going to be different enough from the current petition that's before you that we would be able to bring it back to the BZA at that point.
The original request was for setback variation, wasn't it? From 2 feet to 5 feet. Isn't that what we originally started here for? And then we found that they did not get a permit at all, a building permit at all.
There's a number of things.
So we're on top of that, aren't we?
There's a number of things at play here. They're asking for basically two things. They're asking for the expansion of a non-conforming structure, which is in the form of the canopy structure, that frame structure that was erected that doesn't comply with city standards. They're asking for you to basically approve the expansion of that building based on that structure. And along with that, the setbacks that are necessary to be able to place that structure where it's located. And they haven't provided us with enough information to properly review the request. They say that that's being worked on, but it's been being worked on for almost a year and a half now. In
So-
some capacity or another.
So if we dismiss the petition and then you say that you have to enter into conversation with them again in order to resolve the violation, what in your mind does that mean? That they have to take that structure
So
down?
if the owner were to propose a structure that complies with city standards in all respects except for setbacks, for example, because no matter what, the setbacks potentially are going to be an issue if they intend to place some sort of a cover over the current patio space. But I would be willing to entertain a staff recommendation in favor of a request that would comply with city standards in all other respects. And we've made that clear to the petitioner in previous conversations. So
What time limits can we put time limits on this? Can we say,
I wouldn't
I mean, for
I wouldn't
instance-
do that. We've already done that. We've already given, I don't know how many times we've been before this body at this point with meetings. This has been on the agenda several times.
I'm not sure I understand, Mr. Klinder, but if you're saying, can you grant a continuance? Yes, you can, and if there's nothing resolved, then you can not grant another one, or you can deny the request at the September meeting. That's the only way this body could impose some sort of time limit.
It's just a time limit on the paperwork and the request. It doesn't do anything to his business. He's still there making.
He's still there.
Doing his thing, day after day, out of compliance. And what obligation do we fall under as far as responsibility goes? The city for having an entity that's doing business that hasn't complied to any of our rules and regulations.
Well, we're currently, this is factual, I can say this, we're currently in a lawsuit with that entity. And so the violation issue basically is in limbo pending the outcome of that lawsuit, whether it's settled in some fashion prior to action being taken, some sort of final action being taken by a judge, or the judge itself, or the judge, themselves would make a determination as to what the resolution of that would be. It doesn't affect the operation of their business. If the building owner, the business owner chooses to put the cover over the structure again, then that forces us into a situation where we have to, revisit the lawsuit. I think sooner than later, because we're basically we're waiting for the outcome of this process to determine whether we're going to go forward with a need to further pursue the lawsuit or settle out of court. But
So us granting him another continuance probably doesn't have much of an effect on him at all.
no, it doesn't have an effect on his business operation. It affects the fact that we have to wait longer to resolve this issue. And frankly, the fact of the matter is there is a violation currently. At this point, it is less of a safety concern than it was originally, and more of a building permit not being granted for the structure that exists today concern. But be that as it may, it's still a violation. So eventually that issue needs to be resolved. But if we were to take action to dismiss this petition, would not affect his business operation from the standpoint of a basic operation of the business that's on site.
But it could help move the lawsuit.
Would also help us potentially move the conversation regarding resolution of this forward.
As opposed to just dragging it out for another month.
Right.
Is there any other comments from anybody on the board? Or does somebody want to make a motion? Sure, thank you.
I'd like to move that petition B 104-19 be dismissed, with the petitioner able to apply at a later date.
I would have two questions, Mr. Norvell. First, the petitioner's asked for continuance, so would you be open to amending your motion to include a denial of the request for the continuance as well as a dismissal of the case?
Yeah, I make a motion that the
Request for continuance.
deny the request for a continuance and that this petition be dismissed.
Second.
Okay, we have a motion and a second on the denial of the continuance and dismissal of the petition that's currently before us. Mrs. Janice?
Yes.
Mr. Klinder?
Yes.
Mr. Norvell?
Yes.
And Mr. Zimmer?
Yes.
Okay, motion passes as stated.
Is there any old business this evening? It is old business, I know.
Yeah. No, there's no old business.
We don't have any new stuff either.
We don't have any old business, we don't have any new business.
Is there any public comment?
There's no public.
No public comment?
There's public. I think Ms. Stransky qualifies as public.
Not hearing any public comment, can I get a motion to adjourn?
So moved.
A second?
Second.
We are adjourned. Thank you.